Class. The Senate Committee on Natural Resources will now come to order. Will the secretary please call roll?
Senator Cruz Crawford, Chair.
Here.
Senator Scheibel, Vice Chair.
Here.
Senator Pizzina.
Present.
Senator Hansen.
Here.
Senator Ellison.
Present.
Okay, we have 5 members present and we have a quorum. Welcome to our audience in Carson City and those joining us by video conference in Las Vegas. And no one's in Las Vegas. And those tuning in over the internet. Before we start, we're going to make several housekeeping announcements. When testifying and you're speaking, please turn on your mic and turn it off to listen. We have listeners and viewers online. We're recording this meeting and it will be available through the legislature's website following the meeting. If you have handouts for the committee, please provide 10 copies to the committee secretary prior to testimony. In addition to exhibits and amendments, they must be submitted electronically as a PDF file for our committee manager no later than 3:30 on the business day before the meeting. Committee information is available on Nellis, which can be accessed through the legislature's website. You may also watch our meeting through Nellis or the legislature's YouTube channel. We ask that public comment be kept to 2 minutes. Written public comment may be submitted before, during, or up to 24 hours preceding the meeting's adjournment. Members of the public may provide testimony on a bill either in person or on the telephone. And finally, please mute your electronic devices, especially your cell phones, during the meeting. Today we have a 15-minute overview presentation about the Division of Water Resources, and then we're going to follow by 2 bill hearings. We're going to hear SB 31 and SB 36. So if the Division of Water Resources would please come forward. We have Adam Sullivan, the state engineer. Please begin when you're ready. You have 15 minutes. We have our little timer here to keep us honest. Thank you.
Good afternoon, Chair, members of the committee. Adam Sullivan, State Engineer, Principal Administrator for the Division of Water Resources. This will be a brief overview of the division. This is also an opportunity to provide some foundational information that I hope will be helpful in considering water bills for this session. There's a lot of different concepts that are proposed, and it's just important to stay grounded, and I hope this is helpful for that purpose. I'll start with some factual baseline information, then I'll discuss some functions of the division, principles of water law that govern what we do, and I'll give you an outlook on some of the long-term water issues that we often hear about. And then I'll close with some points about how our division looks at water bills that are proposed. So some quick facts to start off. Nothing in Nevada water law is easy, but here's just some opening points. We are the driest state in the nation. Most of our water supply is from surface water. There's rivers that's providing water for our 2 major municipal areas, our major irrigation districts. About a third of our water supply is from groundwater. And this is really where the greatest challenges are in administration because the data are limited. And it's really harder to understand truly what our long-term water supply is from groundwater. Water use by volume is primarily used for irrigation, about 70% for irrigation, 10% for municipal, and 10% for mining. And that's just general numbers for all sources of water. On the next slide, I'll give more specific data on groundwater use. We're still among the fastest growing states in the nation. The water law that governs what we do has a lot of history, generations of history. The same foundational principles that we operate under are the same for all the other semi-arid western states. Water rights that are already appropriated across most of the state exceed what we estimate as the long-term water supply. So that's the amount that we could use indefinitely without running out. This is a statewide summary of groundwater usage and groundwater committed and how water is used. Across the x-axis shows the different manners of use. The paired columns show in the dark color the amount that's actually used, and in the faded color the amount that's appropriated or permitted. The numbers that you see are pretty similar to the general slide that I showed before, 67% for irrigation, 8 to 10% for mining and municipal, lesser amounts for other manners of use. Something to take out of this graph is that existing rights to use water are about double of what is actually used for all the manners of use. Now, some of that is because people are efficient. You don't use all the water that you can potentially use, but some of that represents water rights that are really not in use. The scope and responsibility of the Division of Water Resources is to carry out Nevada water law, to use the best available science to protect the resource and support and protect existing water right users. The office was created in 1903, really with two distinct purposes. One was to quantify the water rights and make determinations of the water rights that were already in use, which was essentially all the surface water source at that time. The second purpose was to come up with a process for appropriating new water rights, anything that came after 1905. Now, groundwater wasn't really available in 1905. As well, technology developed later on in the 20th century. Groundwater was incorporated into the same basic principles for appropriating any source of water, and that was in 1939. The jurisdiction of the Division of Water Resources is for all sources of water, both above and below the ground, with the exception of the Colorado River. The Colorado River Commission is a separate state agency that has jurisdiction over the interstate compact, and the Southern Nevada Water Authority really negotiates on behalf of the state. All other water rights in the state are processed through and then documented in our office. And this is an increasingly complex process, and it's the bulk of what we do. Other duties, we're still in the process of determining those pre-statutory rights, so that's pre-1905 for surface water, and this is the subject of the next bill hearing that you'll hear after this. We keep records of water use, well drilling oversight, dam safety, distribution of water in accordance with decrees. So there's a lot of diversity of work that's done there. This is an essential service. Every facet of Nevada's future is reliant on the effective administration of the public water resource. Economic development and diversification requires water. Public health and housing requires water. Protecting the environment requires water. So the scope of what our division does is defined by water law. We also work cooperatively with other entities that have authority over water use, the municipalities, irrigation districts. We all have a common interest in protecting the resource for the benefit of the public. Everything our office does is governed by Nevada water law. Here's some basic principles that are an important foundation. First, the prior appropriation doctrine, first in time, first in right. If a water use was in place first and has been continually used, then it has priority over what other water uses that came after that. The priority date of a water right is an important element because it defines the relative priority of that right compared to others. Beneficial use is the basis, the measure, and the limit of the right to use water. That's right out of statute. Every major step of our internal review process is tied to beneficial use, from the application to extensions of time, to proving up, to showing continued good status. It's tied to beneficial use. And then use it or lose it. If there's no need for the water, then the right to divert it ceases. That's also straight out of statute. Unused water rights can't be held without reasonable diligence towards beneficial use. Who owns the water? The public. The water right is a usufructuary right, and it's the right to use the public resource when it's available and when it's in priority. A water right itself can be transacted like a private property right. You can change ownership, you can move it around within a common area, but it's always tied to a use. The value of a water right is in its beneficial use, and the water itself is never owned. We're facing some major water challenges when it comes to long-term administration. There are increasing demands for water supply to support growth. We have needs for water, we have needs for growth, it all takes water, and there's often not enough to go around. Secondly, there's a legacy of existing appropriations exceeding the long-term supply, like I mentioned before. In some areas, this is a really acute problem where we have a chronic groundwater level drawdown, depletion of springs and streams. In other areas, it'll take centuries for those kinds of impacts to be measurable and observed. Different water issues are very local by nature. There isn't much new water to appropriate, so a lot of what we're doing is just changes of existing rights, preventing conflict with existing rights in the consideration of change applications is paramount in what we do. And when I say conflict here, what I'm talking about is where one person's water use is inhibiting the access of another to water on a priority basis. Quantifying the potential for conflict in the application process, and then quantifying actual conflict maybe decades after it's already been in use is getting more and more difficult as time goes on and with the data limitations that we have. Fourth point, there's been a trend in the modern area to deviate from the kind of strict basic principles to add new exceptions or special cases to protect different interests. This is understandable, but it has the cumulative impact of slowing down our work, of creating the potential for errors, and at times leading to assertions that we're being capricious in our decision-making. And this is a problem. An example of this is the process of getting unused water rights off the books. And I'm going back to the first the column chart that I showed, where there is a lot of water appropriated that's not actually in use. There's an expectation that we do it as part of our workflow. It's a fundamental principle of water law, but at the same time, we don't want to incentivize overuse or penalize conservation. So in reality, water rights are rarely lost through especially through the forfeiture process. It happens much less than is commonly perceived. And in part that's because you really had to have zero use for a long period of time to even be subject to potential forfeiture. It's also in part because the procedures as they've been amended are deferential to the holder of that water right, even when there's no real need for the water. So that can be harmful to those who really are actually using water or have the immediate need for water. So in that sense, forfeiture can be protective of those who are actually beneficially using water. And the last point, insufficient updated data to determine water availability. This is true, but there is a lot of good work that's happening now to overcome that. The work that's being done through the Nevada Water Initiative is exactly what we need to set ourselves up for long-term water security in the future. And there is an event on March 27th that I want to point out on the second floor that in part is featuring the work of the Nevada Water Initiative. And what this is doing is updating the baseline science that we really need in administration of water rights to support growth where there is demand and a need for and water availability, to protect natural resources, and to protect existing rights. Implementation of Nevada water law. And here what I'm talking about is what our office does and how decisions get made. There's a well-defined procedure in statute for how an application is received, for the public noticing, timelines, and the general parameters that we use to review an application. Water law is very effective for this. This is the day-to-day work that we do. We get about 1,000 water right applications per year among all the other things that we do. And so the procedure for evaluating that is consistent. But the facts are always different on each one of those applications. There's always different complexities, and rarely do we get one that's easy. We have an excellent staff with the expertise to process this work and treat every applicant the same, with no vested interest in the outcome of these decisions. This is really important to maintain that kind of objectivity. So there's a second element of what we do with managing shortages, the problem of over-appropriation, and finding common viewpoints on what to do about that, as well as significant concerns from the public, protecting the environment, assuring long-term sustainability. Water law is less prescriptive about how to address that. What our office is doing within our capacity is to prepare as best we can to address this in the long term. That means a lot of public outreach, sharing the data, supporting the update of the science through the Nevada Water Initiative, digitizing and modernizing our processes, cross-training staff to build and maintain institutional knowledge. We got 10 new positions from the 2023 legislature. They've all been filled. It's been really helpful to get through some of our backlog, and in time we'll really improve our processing capability, but it takes a long time to train people and understand, really have a good feeling for how to do this work. So the long-term challenges that we're facing today took decades to develop. This is not new, and there's no quick fix. We need to proceed really thoughtfully. So, as you know, proposals to change water law are always very contentious. As a division, it's critical for us to stay objective and help move in the right direction. So there is a way that we look at any proposals to change water law. And this is my last slide.
Okay, perfect. I was just gonna say, we hit 15 minutes.
Okay, I'll wrap this up quickly.
Thank you.
But this is what we do with any proposal to change water law that's before us. And there's a set of criteria. First, does it uphold the basic principles of water law? Secondly, does it really protect the aquifers and protect existing users? Third, is this a narrow fix? Is it designed for a specific area? And what are the implications for the rest of the state? Fourth, what is the underlying issue? And if we can identify that, is there a way to deal with that within our current statutory structure? And then last, what is the implication for our workload, for our efficiency, and is it gonna cost more money? So when I testify on a bill, this is where I'm coming from, and I will try to articulate what my reasoning and viewpoint is on anything in that context. So I hope that's helpful to know. And with that, I will take any questions.
Thank you so much. I know being a state engineer is not the easiest job, so I really appreciate your work and you working with me and all the other entities helping educate someone that didn't know anything about water about 5 weeks ago. So I appreciate that. Committee members, is there anyone that has any questions? Yes, Senator Ellison.
Thank you. Thanks for the information. I did have a question, and I brought this up before, is that, do we have a formula or something that, like mountain use coming down to the aquifer? What is actually going into the aquifer from the snow levels? Have we have any idea how much that is? You know, because we're still going on 1950 studies on some areas, so it'd be kind of good to know if we're ground seeding or seeding the mountains, like the Ruby Mountains. how much is actually going into the aquifer in them areas? Have you got any idea for that?
Thank you for the question, Senator Ellison, Adam Sullivan, for the record. Yes, this is exactly what the Nevada Water Initiative is doing now. We do rely on data that in many parts of the state that is 50 to 70 years old. It's not necessarily bad, but it needs to be updated because we've collected a lot more data since that time, and we have better methods to evaluate exactly what you're talking about. What is the natural resource recharge that's occurring in the mountains? What's the natural discharge? What is the actual consumptive use from that is happening now? What's happening in the aquifers with water level data? What's the connectivity from one administrative basin to another? These are all questions that are really, really critical to have a foundational understanding so that we can make well-supported and defensible decisions. So that's one of the priorities of our office now, and I appreciate the recognition.
Thank you so much. And yes, DRI is doing some great job measuring how much water we actually have, so we can do a better job working through these processes. So thank you so much. We are going to begin our next bill hearing here. We're going to have Senate Bill 31. I will now open the hearing on Senate Bill 31. This measure revises provisions relating to the adjudication of vested water rights. We have our state engineer again here, Adam Sullivan. He is going to be presented. You're going to get 14 minutes and 30 seconds because you took that from the previous presentation. And okay, perfect. Please begin when you're ready.
Thank you, Chair, members of the committee. Adam Sullivan, State Engineer, Administrator of the Division of Water Resources, and with me is James Bolatin, Deputy Administrator for the Division. I will start off with a sort of general overview of the intent of this bill, and then James will go into more of the detail and the explanation of what it's really all about. But so to start with, from my perspective, this bill is really about the division being able to complete its work comprehensively and without having loose ends with regard to claims from federal agencies. And so the division is responsible for adjudicating pre-statutory water rights. And this is what I talked about in the last presentation, pre-1905 or pre-1939 for groundwater. And in 2017, there was a new law that was established that set a deadline for any new claims of vested right that those all needed to be submitted by the end of 2027. And there was an important exception for federal agencies because there's a limits really on what the state can require the federal agencies to do. And the testimony from 2017 made that clear. But there was this important piece that was left out. The law was clear about federal reserved rights, but didn't mention federal claims of vested right. So this bill really is intended to fix that so that we can proceed with our work and we have a clear path and it's for rules for how to that we can include federal agencies in this state water law procedure. We anticipate some opposition to this, really on principle about the state versus federal interests, but really what, as I see this bill, what it's doing is it's providing assurance that federal agencies are included in this state water rights procedures, and I'm aware of a few amendments that I think help support what we're trying to accomplish here, and I'm certainly open to working with amendments that are complementary to what we're trying to do. And with that, I will turn it over to James, who has a much more comprehensive understanding of this.
Yes, please state your name and spell your last name for the record. Thank you.
For the record, James Bolatin, Bolotin, Deputy Administrator of the Division of Water Resources. The changes proposed in SB 31 are minimal but necessary changes that will ensure compliance with the federal government's limited waiver of sovereign immunity under 43 U.S. Code Section 666, also known as the McCarran Amendment. Sovereign immunity is a legal doctrine under which the government cannot be sued without its consent. Under the McCarran Amendment, the United States has waived its sovereign immunity for the purposes of the adjudication and administration of federal water rights under state law. An adjudication of water rights is the state's process for determining the vested rights of parties on a water source. And vested water rights are those claims that allege appropriation and beneficial use of water predating Nevada's adoption of water law in the early 1900s. The McCarran Amendment allows Western states like Nevada to force the United States federal government into the state adjudication process, including forcing them to be a party in our state courts. It ensures that the adjudications include all parties, including the federal government. This change in Section 1 of SB 31 exempts the federal government from the deadline to file claims of vested right by the December 31st, 2027 deadline currently in statute. It does not, however, exempt the federal government from participation in the state adjudication process under the McCarran Amendment. Rather, we see this change as necessary to ensure that the state can force the United States' participation in these proceedings. In current law, NRS 533-087, all vested right claims must be filed with the state engineer by December 31st, 2027, to be considered in future adjudications. In the early 1990s, the state of Oregon had a very similar statutory deadline for filing claims of undetermined vested rights or federal reserved rights, and the federal government successfully sued the state of Oregon to be exempt from the deadline. The Ninth Circuit Court of Appeals held in 1994 in the case of U.S. versus State of Oregon 44 F. 3rd 758 that the United States' limited waiver of sovereign immunity in the McCarran Amendment applied only once an adjudication was opened by the state. The Ninth Circuit held that this statewide deadline for claims was too far removed from the adjudication process to be characterized as part of the adjudication, and therefore this claim deadline did not fall under the U.S.'s waiver of sovereign immunity under the McCarran Amendment. The Ninth Circuit held that in the absence of the waiver of sovereign immunity, Oregon could not require the United States to register its water rights claims statewide by the deadline in statute prior to the state actually initiating a specific adjudication of the water source. Nor could Oregon prejudice such federal claims in an adjudication if the United States failed to file their claims before the deadline. An exhibit with the relevant portion of this case decision is posted on Nellis for the committee's consideration. If the state engineer were to enforce the statute as it's currently written and reject claims for vested rights by the United States after the 2027 claims filing deadline, the U.S. v. State of Oregon case from the Ninth Circuit indicates that Nevada would likely face a challenge by the federal government in federal court and would likely lose on that issue. To avoid becoming embroiled in this litigation and ultimately being on the losing end and further delaying any adjudications that are initiated after 2027, the division recommends the change in Section 1 exempting federal agencies from the claims filing deadline for any potential vested claims. This is the reason for this bill, not to give the federal government special treatment, but rather to address and comply with the special treatment that the federal government already receives through sovereign immunity. The federal government may file two different types of claims for water rights during the adjudication process: claims of vested rights and claims of reserved rights. The vested rights are the same as those that may be asserted by non-federal entities. Those claims of appropriation and beneficial use of water prior to the state's adoption of its water law statutes in the early 1900s. However, claims of reserved rights are based on federal actions setting aside land or reserving it for a specific purpose, which also reserves a sufficient amount of water available to support the particular purpose of the reservation. These reserve rights arise from reservations such as those that create national forests, national parks, national monuments, as well as tribal reservations. Importantly, the statute as currently written already allows the United States to file reserve rights claims after the December 31st, 2027 deadline once the state engineer initiates an adjudication. The changes proposed in this bill simply allow the United States to also file its vested claims once the adjudication is initiated by a deadline that will be set by the state engineer when he starts one of those new adjudications in order to ensure compliance with the McCarran Amendment and to ensure that the United States can be joined in the state administrative proceedings and ultimately state court proceedings. Again, as I just stated, the change in Section 2 of SB 31 allows the federal agencies to file either type of claim after the 2027 filing deadline, once the state engineer starts a new adjudication. The version of NRS 533.095 in effect beginning January 1st, 2028, after the filing deadline, requires only that federal agencies making claims of reserve rights are required to make proof of their claim. The change in Section 2 of SB 31 allows federal agencies to also make their claims on vested rights once the state engineer gives notice that he's starting a new adjudication. Making these changes resolves a vulnerability in Nevada state law that the federal government has successfully defeated when Oregon had a nearly identical scheme. By ensuring a proper waiver of the United States sovereign immunity, the state engineer can require the participation of the federal government in the adjudication process. This way, Nevada can ensure that state court decrees are complete and address all claims of vested and reserved rights within a water system, including those claims by the federal government. Nevada has many more water sources that have not been adjudicated, and those adjudications are likely to be initiated following the December 31st, 2027 deadline. It is in the best interest of the public to only have to engage in the adjudication process one time on a given water system by bringing all of the parties, including the federal government, before the state engineer and ultimately the state court. Therefore, the division believes that SB 31 is a necessary change to ensure that these future adjudications are fully comprehensive. To reiterate what the state engineer has previously stated, we have also seen a couple of amendments that we are open to considering to ensure that the goal of this bill is achieved. I thank the committee for its time, and I'm happy to answer any questions the committee might have.
Thank you so much. We got back on the good list here. Took back some time. Do we have any questions from our committee members? Senator Scheibel, and you can talk directly through her.
Okay, thank you. Excuse me. I appreciate you bringing forward this legislation and explaining it to us. And I want to make sure that I'm understanding kind of the deadlines and the implications of passing this bill, because it's my understanding that essentially the Ninth Circuit already told us that our deadline doesn't apply to the federal government, right?
James Blodden, for the record. That's correct, Senator Scheibel.
Okay, so if we don't pass this legislation and then we get past the deadline in 2027, we would not really have a mechanism in statute to require the federal government to come into state court and adjudicate their rights in state court because the McCarran Amendment doesn't apply and the deadline has passed. Is that correct?
That's mostly correct. James Blodden, for the record, Senator Scheibel. And I think it's even worse than that. The current language of the statute, following the plain language of it, I think would require the state engineer to reject the federal government's claim for a vested right if it came after the deadline, which would put us in direct contradiction of that Ninth Circuit precedent and likely lead to litigation that I'm not sure we have a defense to win.
And to be clear, when you say rejecting the claim, you don't mean that the state engineer would be forced to find in favor of the Nevadan that is disagreeing with the federal government. You mean that the state engineer just wouldn't be able to adjudicate the claim at all?
James Blodden, for the record, that's correct. The state engineer would not be able to accept the claim from the federal government, and therefore it wouldn't be able to be included in the adjudication based on the way that the statute is currently written.
So a farmer, for example, somewhere in Nevada, and the BLM could be in an argument over whose right has vested in a particular water source, and without passing this bill, the state engineer's hands will be tied and he or she will not be able to adjudicate that claim in favor of either party.
James Blodden, for the record, I definitely think it would be messy, Senator Scheibel, because it would put the division and the state engineer in an impossible position of if that farmer had gotten their claim in, but the federal government didn't get their claim in time, but the deadline had passed, the state engineer would have to reject the claim, even though really he doesn't have the authority to hold him to that deadline. It would result in litigation, and it's just better for everybody if everybody's claims can be included in one adjudication, go through the state engineer's administrative process, and ultimately submit the federal government to state court jurisdiction to have these rights determined once and for all.
Thank you. And you did mention in your presentation that you anticipate some opposition. Could you talk a little bit about what the opposition to this bill would be, or what you've been hearing?
Adam Sullivan, for the record. The opposition is a reaction that the federal agency shouldn't get a special carve-out that everybody else has to abide by in the adjudication process. We have this deadline, it's the end of 2027. The intent was that we reach finality on these adjudications. So that's my understanding of the opposition, that it feels like we're giving a special carve-out for federal agencies.
Okay, and I appreciate that sentiment, but it also sounds to me like the Ninth Circuit already made a decision giving a special carve-out to the federal government in Oregon, and so we're making an educated prediction that the same thing would happen in Nevada if we don't proactively allow the federal government to continue to bring claims.
Adam Sullivan, for the record, that's a good way to put it, yes.
Okay, those are all my questions. Thank you.
Okay, I think we need Senator Scheibel to help present with you all next time. Because I feel like a lot of people just understood it a lot, and you guys did a great job, but I appreciate that very much. Okay.
There may be questions down
I just did a small.
Oh, never mind, Senator Scheibel, you got Mr. Ellison to have Senator Ellison to have a question, so you are not.
I've got a real small one.
Go ahead, Senator Ellison, you can speak
Would
directly.
that be challenged in the state court here, or federal state court, or would that be in federal court in Washington?
My understanding, James Bloughton for the record, my understanding, Senator Ellison, would be that because under the Oregon case, there had been no proper waiver of the federal government's sovereign immunity, they would be able to hear the case in federal U.S. District Court.
Thank you.
Okay. Seeing no other questions, we are going to, if you can go ahead and go back to your seat for a moment, we're going to take testimony in support. Okay, if you have testimony in support, go ahead and come up here. As a reminder, we'll be limiting to 2 minutes each. Testifiers are encouraged to summarize your positions if you have more comprehensive testimony. You may begin when you're ready. First and last name for the record.
Good afternoon. Alex Tanchek with Silver State Government Relations.
Sorry, can you spell your last name?
Last name is Tanchek with Silver State Government Relations, representing the Pyramid Lake Paiute Tribe, here in support of the bill. Thank you.
Okay, we are going to take any testimony in support over the phone. AVH, is there anyone on the phone line wishing to provide testimony in support of Senate Bill 31?
If you would like to testify in support of SB 31, please press star 9 now to take your place in the queue. Caller, please continue.
Good afternoon. Quick comms check. Can everyone hear me okay?
Oh,
Yes, they can. Go ahead.
Okay, thank you. Thank you to the chair and to the members of the committee. My name is Captain Kyle Hoffmeister. I'm a judge advocate and regional environmental counsel for the Department of the Air Force. First, I want to thank you all for the opportunity to speak with you today. On behalf of the Air Force and Department of Defense, I'm here to discuss Senate Bill 31, which, as explained, would exempt federal agencies from the requirement to file their vested water rights claims with the state engineer by 2027. Instead, federal agencies would be required to file their water rights claims when the state engineer enters an order granting a petition for a comprehensive or basin-wide water rights adjudication, as has been the law for many years. The proposed amendments to Nevada revised statutes 53087 and 533087 and 533095 contained in Senate Bill 31 provide a correction to Senate Bill 270. And as discussed, Senate Bill 270 established a process which, as applied to the United States, did not comply with the McCarran Amendment's limited waiver of sovereign immunity. Additionally, the revised language clarifies that vested claims owned by federal agencies will be filed at the same time as federal reserved water rights claims, which have vested pursuant to federal law, instead of two separate waves of filings. As you all know, the Department of Defense installations in Nevada play a critical role in our nation's defense, and water rights held by the United States are crucial to the Department of Defense mission. These military installations are among the many federal land holdings which could be impacted absent the enactment of Senate Bill 31. Senate Bill 31 conforms to NRS 533087 and 533095 with the principle of federal sovereign immunity, consistent with the McCarran Amendment. These safeguarded water rights are crucial to the DoD mission. We appreciate your recognition of the United States limited waiver of sovereign immunity and the important role the United States plays when it participates in water rights adjudications. Moreover, we appreciate those rights as well as your continued support of the Department of Defense. Thank you again to the chair and members of the committee for your time. Over.
AVH, is there anyone else on the line wishing to provide support testimony?
Chair, you have no more callers at this time.
Okay, great. Next, we'll hear testimony in opposition of Senate Bill 31. If you have opposition testimony, please come up, say and your first and last name and spell your last name for the record, and you may begin.
Thank you, Madam Chair, members of the committee. I'm Jake Tibbetts, and I'm the Natural Resource Manager for Eureka County, and I'm representing Eureka County today. So we understand the stated reason for SB 31, but we believe the language needs further clarified related to when federal agencies would be required to file claims and how other claimants would be able to amend their claims when a specific adjudication were initiated by the state engineer. So we'll point you to an amendment that we have put forward, and it's on Nellis. So we are thankful to the division and others that are willing to work towards some agreeable language. Regardless of this bill, we believe it is important for all claimants, including the federal agencies, to have to file claims and get them on the books. So everybody knows who's on the playing field in managing the water resources and water rights. How can water be effectively managed otherwise? How can existing rights, including the rights of the federal government, be protected if nobody knows what those rights are? So as such, we find this situation a bit odd where some of the federal agencies are arguing against the 2027 deadline, understanding all the legalese behind it. But I'd like to just quickly focus on some policy from the Bureau of Land Management. The BLM has an instructional memo from the Nevada office. They actually have 3 of them that I've found. I'm quoting from one of them here where the language is very similar, and it's in their IM 2013-007. And it states, this is word for word, under a section called Public Water Reserves. Quote, pursuant to an existing agreement with the Nevada State Engineer, field offices shall notify the state engineer regarding the surface water, springs, and water holes on public lands that qualify as public water reserves, end quote. BLM Water Right Manual MS 7250 also has similar language related to that nationwide. And one of those I'd like to point to is in section 1.4B7, where it's the state director's responsibility of, quote, documenting BLM water rights by location, land description, and recordation in BLM master title plats and historical indexes.
I apologize, you're about
this is-
over.
okay.
Oh, I just don't want people to think I'm playing favorites.
And
you know.
inappropriate local and state systems of record for property rights. So with that, even though we understand the intent of this bill, we still think it's very important for all water rights claimants to get their claims on the books so we know where people stand. Thank you.
Okay, Joey, you have 1 minute and 46 seconds. He took 14 seconds of yours. Go ahead.
Madam Chair, members of the committee, my name is Joe Guild. I'm here in opposition to SB 31. First, I'd like to thank Division of Water Resources and James Balatin for our conversation the other day, which helped me illuminate a few things. if there is a discussion about an amendment, I would like to be a participant in that. And I'm here on my own behalf. I'm a rancher in Nevada, been operating as a lawyer in this arena for more than 40 years. And my concern is pretty much what Jake Tibbetts just said, that the intent of the amendment, and I've provided copies of that amendment to the committee, and I'll paraphrase that amendment in a second. But as to the Oregon case, there is some distinction. We're talking about the Klamath River, one basin, surface rates only, with significant reserve rights associated with that. So we've got a case from one court supporting something that happened, by the way, many years before the 2017 bill was passed here in Nevada. And so I think there's some distinguishing factors there that should be considered. And from the case, one of the rationales, I'll quote from the case, there's, as on behalf of the federal government, there is no relation between the deadline for filing registration statements and the commencement of the statutory adjudication. That same rationale could apply to a private water rights holder in the Klamath Basin.
Thank you so much. That is 2 minutes. If you have additional comments, you can give it.
Well, I would like, if I could take one more minute, Senator, and paraphrase the McCarran amendment, I'd sure appreciate it.
Would anyone up here like to give him his minute?
Can I ask a question?
I don't think I'm gonna take that long. So.
Okay, perfect. We'll give that minute. And did you want to ask a question? Go ahead, Senator
It'll be
Scheibel.
less than a minute.
Go ahead, Senator Scheibel.
Oh,
Finish first.
thank you. Paraphrasing the McCarran amendment, which is in front of you. For the administration of such rights by the federal government, where the U.S. is the owner or in the process of acquiring water rights by purchase, exchange, or otherwise, and that would be the case in filing a vested claim of right, the U.S. is deemed to have waived its right to plead state laws are inapplicable, and the U.S. shall be the subject to the orders of the court of jurisdiction, exactly the words from the amendment, and the U.S. may obtain review in the same manner as private individuals. And my point is, the federal government should be subject to this deadline, just like every other appropriator who have had 10 years to check out their vested rights and file claims for them. And thank you for the additional time.
And thank your colleague there. Go ahead, Senator Scheibel.
If you don't mind answering a question, I know it's not customary during testimony, but I think you raise a really interesting point about the distinctions between the Ninth Circuit case in Oregon and us. And you mentioned there being one basin only, and it was, I think you said it was surface water only that was involved in the Oregon case.
Correct. Joe Gill.
And I guess I'm wondering why you think that tends to suggest that the federal government would make a different decision if a Nevada claim came before it.
This is Joe Gill. Well, with all due respect to a fellow attorney, Senator, I can't speculate, but I do think that raising the distinctions is an important point to come to the table together, which is what I said at the beginning of my remarks, and figure out a way. Maybe this is, in my opinion, this amendment to the statute is, it fails for a lack of context, let's put it that way. And so I'd like to be part of the discussions on any amendments. And the McCarran amendment is a very, very rock-solid bedrock for Western water law particularly. And so I think we should be very careful in our attempts to amend it.
Testimony in opposition, please state your first and last name and spell your last name for the record. Thank you.
Madam Chair, thank you for the time, and members of the committee. My name is Davey Stix, S-T-I-X, member of the Nevada Cattlemen's Association and a water holder of both surface and groundwater rights. We are here today to voice opposition to this bill for the following reasons. Under federal law, waiving their sovereign immunity, and with all the resources at their disposal, meaning the federal government, and the fact that any government entity has a much higher threshold to prove beneficial use, you need to ask why, and that is the most important question. Why should the mighty federal government need leniency or special dispensation in something so important? My family, as a personal testimony, are working diligently to achieve making the deadline for 2027 in several water-related issues with limited resource and little might. And we're almost there. Again, the Nevada Cattlemen's Association asks that you please vote no on this matter. Thank you for the time.
For the record, I'm Doug Busselman, the Executive Vice President of Nevada Farm Bureau. Busselman is B-U-S-S-E-L-M-A-N. We are opposing SB 31 on the basis that we believe that the federal government is being granted unfair preference and don't believe that it's necessary for this bill to include the provisions that are being proposed. It was our understanding that the purpose for adopting NRS 533.087 and requiring proofs of vested rights was to get these unknown claims on the table within the time frame, December 31st of 2027. The current law says that if a claimant files or fails to file such proof on or before that date, December 31st, 2027, that claim will be deemed to be abandoned. The private sector, they're out of the game if they don't turn in their paperwork on time. As we read the new language, this doesn't apply to claims that the federal government decides that they have. A private sector right owner has to comply with the December 31st deadline, but the federal government doesn't have to do anything and can file their claims long after a private sector landowner has been they've had their rights abandoned, if they didn't jump through the hoops that the federal government didn't have to comply with. We appreciate the discussions that have been taking place prior to this hearing, and we welcome clarifying amendments that have been proposed or might still be pending. In a state which is so dominated by federal agencies exerting their authority, sometimes on the basis of what they themselves have decided as being theirs, we think there should be more of a level playing field, which SB 31 seems to not require. Thank you.
Jay Dixon, for the record, D-I-X-O-N, with the Water Strategy Group. I'm testifying today on behalf of BTAS Nevada in opposition to this bill. BTAS Nevada is a substantial agricultural producer. We run up to 15,000 head of cattle throughout central and northern Nevada. And on behalf of BTAS, I am working on filing several vested claims in a central Nevada basin, one of the last remaining river systems to not be adjudicated. And we have been working for the last 7 years, preparing, doing all of our research and backup for these claims. And we got 1,030 days to file those, and we will meet that deadline. I used to be in support of having a firm deadline for filing claims because it provides some finality, and it gives the state engineer a tool to assess existing rights in making the decisions that you heard the state engineer talk about. This is important. But if the federal government can get more time, I understand the implications of the McCarran Act, but there's a serious equity issue here. And in my opinion, the existing law is equally unenforceable because it cuts off private vested rights after December 31st, 2027. Thank you.
AVH, we'll now take phone lines for anyone in opposition to Senate Bill 31. AVH, is there anyone on the phone line wishing to testify in opposition to Senate Bill 31?
Chair, your public line is open and working, but you have no callers at this time.
Thank you. That's what, I love this committee. All the ranchers are here in person, sharing their testimony. Okay, now we're gonna move to neutral testimony. Is there anyone here in person in Carson City that would like to testify in neutral? Please state your first and last name, spell your last name for the record whenever you're ready. Thank you.
Thank you. Good afternoon, Chair. My name is Paul Taggart, T-A-G-G-A-R-T. I'm a water attorney in Nevada. I've been being a water attorney for 30 years. I've litigated McCarran Amendment cases my entire career. And I completely support the concept to make sure the federal government's immunity is waived in a state adjudication. That's why Senator McCarran from Nevada got that amendment passed to solve some adjudication problems in Nevada at that time. I think there's a better solution. I think the deadline is the problem. So my point is, if you remove the deadline and the state engineer initiates an adjudication in the state of Nevada, then everyone would be required to comply with that. It's the deadline that creates the problem. If the deadline didn't exist for anyone, then the federal government would not be able to claim that it's a registration requirement, which is what the Utah case talked about. And if it's an adjudication that's initiated by the state engineer, then the Utah case is distinguished completely. So it's unfair. That would address the opposition's claims that it's unfair to give the federal government special treatment. The way to solve the problem, in my opinion, is to get rid of the deadline completely, which in my opinion is unenforceable anyway. It has its own problems. When the Nevada water law was adopted, it was found to be unconstitutional by Judge McCarran at the time, Justice McCarran at the time. And Justice McCarran said that the statutes of Nevada cannot impair vested water rights. So a deadline on vested water rights is a statute that is impairing those vested water rights. So we will litigate that deadline itself. So just like they claim that, so to resolve all the litigation over the deadline, I would suggest you delete that completely, and that would solve the problem with the federal government as well. Thank you.
Madam Chair, members of the committee, Kyle Roehring, I'm Executive Director of the Great Basin Water Network. You all are in the unenviable position of trying to make interpretations of the McCarran Act, and I just want to come up here and say that give the process some time and let all these parties work together and try and figure something out, and it's important to be prudent on these matters. This is really, really important for the future of water in this state. Thank you so much.
AVH, is there anyone online wishing to testify in neutral to Senate Bill 31?
Chair, your public line is open and working, but you have no callers at this time.
Thank you. Would you like to make any closing statements? Okay. Go ahead and state your first and last name and spell it for the record. Thank you.
James Blount for the record. I just want to thank the chair and the committee for their time and consideration of this bill. I think as you heard from the testimony, even opposition, there's some issues with the way that the statute currently applies to the federal government. It is not the division's goal to give the federal government special treatment. We just want to make sure that the statute is constitutionally compliant and that we can get the federal government's sovereign immunity waived and get them into these adjudications so they include all claims. And as I stated previously, we're looking at the amendments and we continue to be willing to work with the other stakeholders on those. And thank you again for your time.
Thank you. Yes. Great presentation, great testimony. We're making one kid fall asleep in the audience, but we are all ready to hear our next bill hearing. We have Senate Bill 36. I will now open the hearing for Senate Bill 36. Give everybody a minute to shuffle. I will now start the bill hearing on Senate Bill 36, which is a measure that establishes provisions relating to the conservation of groundwater. It is with great honor. We have one of my favorite senators, Senator Pazina, here to present. We have Laurel Saito and Jeff Fontaine. I said your name correct? Okay. You may begin when you're ready. You have 15 minutes.
Thank you so much, Chair Cruz Crawford and Vice Chair Scheibel, who I realize is also one of the chair's favorite senators, and members of the Senate Committee on Natural Resources. For the record, my name is Julie Pazina, and I represent Senate District 12 in Clark County. Thank you for the opportunity to present Senate Bill 36, which establishes provisions relating to the conservation of groundwater. I had the pleasure of serving as chair of the Joint Interim Standing Committee on Natural Resources during the 2023-2024 interim. And as you know, Nevada is the most arid state in our nation, and as such, the interim committee had many difficult conversations on water scarcity and the tools needed to address that issue. The interim committee learned about the water rights retirement programs in other states, as well as Nevada's voluntary water rights retirement pilot program. Based on the recommendations made, the interim committee unanimously voted to carry the bill before you today. And with that, I am going to be very mindful of our 15 minutes and hand it over to Laurel Saito and Jeff Fontaine.
Thank you so much. So my name is Laurel Saito, and I am the Nevada Water Strategy Director for the Nevada chapter of the Nature Conservancy. And we thank Senator Pazina and the Interim Committee on Natural Resources for bringing forward Senate Bill 36 on groundwater rights retirement and recognizing the importance of water resources for the future of the health and well-being of the people and economies of our state. Although many in our state depend on rivers like the Colorado River for water supplies, this resource is limited. And especially in Nevada, we are fortunate to have groundwater to buffer droughts and other disturbances. And we know that overuse of groundwater in some places is depleting this precious resource and impacting other water users as well as our natural resources. Such impacts can take years, decades, or even centuries to reverse. And in some cases, they're irreversible. The Nature Conservancy supports enabling tools to resolve overuse of groundwater that can affect water availability for plants, wildlife, and people. Water law allows curtailment by priority, but this may not resolve the issues if water rights curtailed are not affecting the existing uses or detriments to natural resources. So this bill offers another tool to address these situations. So we've worked with others to develop language in the friendly amendment that will make voluntary groundwater rights retirement an effective tool for addressing groundwater overuse in Nevada. And this tool has been used in states like Kansas and Colorado for many years to address groundwater table declines affecting water users and ecosystems, as indicated in the attachment that's on our submitted testimony. For example, Kansas has retired almost 50,000 acre-feet of groundwater using a combination of federal, state, and local funds with 2 programs. And as you heard on Tuesday, over 20,000 acre-feet of groundwater rights were retired through the pilot program using American Rescue Plan Act funds over the interim here in Nevada. And there was more interest in retiring groundwater rights than funding allowed. So we stand ready to help with implementing a voluntary groundwater rights retirement program in Nevada by building on lessons learned from these existing programs and working with water managers and other stakeholders. And we're also interested in considering ways to incentivize the retirement of groundwater rights to reduce impacts to groundwater-dependent ecosystems. And a good example is what was done in Oregon. So we're committed to continuing to work on the bill and to assist the state in enacting this program by seeking funds and implementing projects that can demonstrate effective groundwater rights retirement. So we urge your support for this important legislation. And I'm going to turn it over to Jeff to go through the friendly amendment that we have put forward.
Good afternoon, Chair Cruz Crawford, Vice Chair Scheibel, and members of the committee. For the record, my name is Jeff Fontaine, Fontaine, and I am the Executive Director of the Central Nevada Regional Water Authority and the Humboldt River Basin Water Authority. And thank you to Senator Pazina for her support of Senate Bill 36. So Senate Bill 36 is, is one of 2 bills that was recommended by the Joint Interim Standing Committee on Natural Resources to establish a water rights retirement program, the other being Assembly Bill 104, which also includes other provisions related to water and wastewater. So SB 36 is a standalone water rights retirement bill, and SB 36 is very similar to SB 176 in the 2023 legislative session, with one very important difference, and that is that SB 36 does not include an appropriation request to actually fund the Water Rights Retirement Program. So the conceptual amendment that's being processed today mirrors a proposed amendment to AB 104 that was developed by a group of water professionals that represent a broad array of interests, including agriculture, local governments, conservation interests, water purveyors, water authorities, and mining, whose names appear on the amendment. And this group is working very hard to make sure that the amended versions of both AB 104 and SB 36 are in alignment. Chair Cruz Crawford, with your permission, I'd like to go directly to the amendments, proposed amendments. They really do delete many provisions in the bill and are somewhat complicated. So if you're okay with that, I'll go ahead and walk through
Yes,
the amendments.
please proceed.
Okay. So, starting with Section 1 in the amendment that is posted on Ellis, Section 1 amends NRS 533.030, which addresses the appropriation of groundwater to make it consistent with the new Section 4 in this amendment, which requires the state engineer to retire all water rights purchased by or donated to the Nevada Voluntary Water Rights Retirement Program. Section 2 amends NRS 533.370, which delineates the conditions, exceptions, considerations, and procedure for approval or rejection of an application for an appropriation of water by the state engineer. This section is also in conforming section with the new Section 4. It also reforms some language in subsection 2 of the original bill. And moving on to Section 3, this is deleted. This is something that's really covered in the new Section 4. New Section 4, which amends Chapter 5, NRS 534, now reads in subsection 1, the state engineer shall retire all water rights purchased by or donated to the Nevada Voluntary Water Rights Retirement Program pursuant to Section 6.6 of this act using any appropriate mechanism as determined by the state engineer and preclude that groundwater from appropriation. Any groundwater right that has been retired pursuant to the section is not available for any use and shall be deemed to be retired from the source in perpetuity. This is a key provision to assure that any water rights that have been retired pursuant to this program are not appropriated in the future. Subsection 2 reflects that this program will sunset in 2035. And in Section 5, this amends the relevant portions of NRS 232, creating the Department of Conservation and Natural Resources to add the provisions in Section 6 through 9, creating the Nevada Conservation and Recreation Program within the Department of Conservation and Natural Resources. In Section 6, this is deleted by amendment and replaced with a new Section 6, which creates the Nevada Conservation and Recreation Program within the Department of Conservation and Natural Resources, which will administer the existing Nevada Bond Conservation Program and a new Voluntary Water Rights Retirement Program, and authorizes the Director of DCNR to adopt regulations to carry out the provisions of this section. A new Section 6.5 creates the account for retiring water rights, which authorizes the Director of DCNR to apply for and accept any gift, donation, bequest, grant, federal money, or other source of money for deposit in the account for retiring water rights, in addition to any legislative appropriations. And again, no appropriations are being requested in the bill, the original bill, SB 36, or this amendment. This section also directs how the money in the account is to be managed and used. New Section 6.6, Sub 1, authorizes the Nevada Voluntary Water Rights Retirement Program to accept donations or purchase and retire water rights from willing sellers in order to, A, protect the natural resources of this state, B, address declining groundwater levels, or C, address conflicts with existing rights or with protectable interests in existing domestic wells. And subsection 2 of the new Section 6.6 directs the Director of DCNR to identify and purchase water rights for retirement from persons willing to retire water rights in target areas within any groundwater basin where A, an order from the state engineer precludes the issuance of new appropriations, or B, the retirement of water rights meets the purpose set forth in subsection 1. This subsection also requires the Director to document in writing the purpose for which the water right has been retired and cause that document to be included in the files of the state engineer. This is really an important piece of this bill as well, to assure that the state engineer has all of the information necessary to manage that basin in which a water rights have been retired. We're adding, let's see, because we're adding subsection 4, essentially this sunsets the retirement program on June 30th, 2035. It's a 10-year period. Section 7 is deleted. This deletes the advisory board to remove the fiscal note. This advisory board was included in the original bill, SB 36. I believe it's very possible that the technical advisory group that worked on the interim program could certainly provide the necessary advice and information with regard to standing up the program. Section 8 is deleted, and this is language about retiring water rights precluding any groundwater from appropriation and not being available for any use. This is otherwise addressed in Section 4. Section 9 deletes the requirement for DCNR to adopt regulations. Section 10 is deleted and is now in the new Section 6. Section 12 adds the Nevada Conservation and Recreation Program to DCNR and removes the advisory committee for the Nevada Water Buyback Initiative, which was proposed in the original version of SB 36. And I think we're getting close to the end, if not at the end. Section 12.5 is a new section that makes groundwater retirements implemented through this program eligible for funding from the program to provide grants for water conservation and capital improvements to certain water systems, which is administered by the State Board for Financing Water Projects. So this is tied to that specific funding source, but that funding source also has its own rules and regulations and is governed by the State Board for Financing Water Projects. And Section 13 deletes, again, the deadline for DCNR to adopt regulations for the Water Rights Retirement Program. And I think that covers pretty much all of the amendment, and be happy to answer any questions.
Committee, would anyone like to ask any questions? Okay, I do have one question myself. What made you make these changes? Why did you make these amendments? Sorry, the conceptual amendment.
So, again, there are two bills. Oh, I'm sorry. For the record, Jeff Fontaine. So again, there are two bills, AB 104 and now SB 36, that have water rights retirement. It's about a water rights retirement program. In SB 36, it's only about the water rights retirement program. In AB 104, the water rights retirement is a portion of a bill that is really being referred to as an omnibus bill and contains provisions related to other water and wastewater programs. So we're trying to align both bills, and AB 104 already has or initiated a proposed amendment.
And this is Julie Pizzina for the record. Also, to answer your question, we are doing everything we can to get rid of the fiscal note so that we are able to hopefully move forward with some good policy to help our state, which is having a lot of water challenges.
Senator Scheibel.
So where will the money come from to pay for the purchasing of water rights?
Laurel Saito for the record. So if we have a fund, then we can do things like fundraising for, groundwater rights retirement, and we have a place to put that money. Or we could apply for federal grants and have a place where that grant money could go for retiring groundwater rights. So we'd like to get the program authorized as well as the fund, because then I think that will enable us to move forward with trying to build up a groundwater rights retirement program.
Thank you. And I understand if you can't answer this, may I have a follow-up?
Go ahead.
I understand if you can't answer this question, but are there funds that are already committed or that we could expect to be deposited when this fund is established?
Senator Scheibel for the record, Jeff Fontaine. So the program does make eligible water rights retirement under an existing program. It's the Capital Grants Program for drinking water systems. And water rights retirement are also an eligible item under the Conservative Nevada Bond Program. And there may be others, but those two are already in place.
Excellent, thank you.
Senator Ellison?
Thank you, Madam Chair. Mr. Fontaine, I'm looking back at section 4, number 2, the state engineer is not to accept any application to retire water rights unless accepted by the director on or before June 30th, 35. Can you explain that, so after 1935, can applications be made or not?
For the record, Jeff Fontaine. So Senator Ellison, I think if you're referring to the amendment, the thought was to have a program at least authorized for 10 years to see how it goes. So I think that's probably the date that you're referring to.
Right.
And we have time to, between now and then, hopefully if this bill is signed into law and enacted, that we can, run the program and see how it goes and evaluate, success, hopefully. And if it needs to be reauthorized, then it needs to be reauthorized. But the idea was to have a sunset on it.
Yeah, thank you.
Oh, we love our puns in this committee. Okay, thank you so much. We'll have you step back while we get public testimony. Next, we will hear testimony in support of Senate Bill 36. As a reminder, 2 minutes each for each testifier. If you have additional testimony, you may share your positions and submit public testimony in writing. You may begin when you're ready. Please state your name for the record and spell your last name. Thank you.
Good afternoon, Chair and members of the committee. For the record, my name is Christy Cabrera-Georgeson, CHRISTI-CABRERAGEORGESON. I'm the Deputy Director of the Nevada Conservation League, and we're here in support of SB 36. Nevada's groundwater is a critical resource for our economy, natural resources, wildlife, and residents. As the driest state in the nation, Nevadans place a high value on the conservation of our water resources. In fact, recent polling shows that 92% of Nevadans are concerned about inadequate water supplies in our state. This voluntary program will provide an important tool for conserving water and reducing the overuse of groundwater. With that, we urge the committee support, and thank you for your time.
Good afternoon, Alex Tanchek, T-A-N-C-H-E-K, with Silver State Government Relations, representing the Pyramid Lake Paiute Tribe, here in support of the bill. Thank you.
Thank you, Chair, members of the committee. Isaac Hardy, representing Moapa Valley Water District and Virgin Valley Water District. Ditto to all the comments and support. We're in support of this bill. Thank you.
Thank you, Chair and members of the committee. My name is Olivia Tanacher. I'm the director of the Sierra Club's Toyabe chapter. We're proud to be here in support of this bill. As you all know, Nevada desperately needs more water conservation. We're in a really precarious spot, and we need every tool in the toolbox possible to preserve our basins and the folks across our great state. So with that, we're proud to support SB 36 and urge your support as well. Thank you.
Hi, Kathy Flanagan, Southern Nevada Water Authority. We are in support of this measure.
Doug Busselman, Nevada Farm Bureau. We also are in support of the bill. Can I save my time for future hearings?
Kyle Roerink, Executive Director of the Great Basin Water Network. We support the bill, and I think it's just important to note that while there may not be funding available right now, if you build it, it will come, and we're hoping that just by building this program, it can attract money to help pay for this. Thank you.
Peter Stanton, S-T-A-N-T-O-N, Walker Basin Conservancy. As the committee's heard, the pilot program in partnership with DCNR was incredibly impactful for communities of the Walker River Basin, and we look forward to working to establish an ongoing funding source with the state and work on federal appropriations to support that as well. So, thank you.
Thank you, Madam Chair. Jake Tibbetts from Eureka County, that's T-I-B-B-I-T-T-S, and I'm the Natural Resource Manager representing Eureka County. And just want to ditto and say that the pilot project that was put in place, we can attest to the interest and effectiveness of the tool, because much of that were interested people within Eureka County, which you may hear from next.
Denise Moyle, I'm a grower. Moyle is my last name, Denise Moyle. I'm a grower in Diamond Valley, Nevada. We're the only basin in the state of Nevada to be in a critical management area. And now we're in a groundwater management plan. We're here to, this is my sister, we're here to speak today on the fact that we were part of the pilot program. We were one of the groups, one of the people that actually received money from the state to speak to a human level instead of all of the acronyms that you hear. Ag isn't getting any easier. It's not any easier to feed the people around us. It's not getting easier to pull the water out of the ground. So the more the water comes up, the more that we can protect our groundwater sources, the more that we can bring up the groundwater levels, the easier it's going to be to farm, and it's not getting any easier. So that doesn't really... in terms of, I think that I think your biggest complaint will be that you don't have funding, and that the funding, when it comes, will be in counterproduction to what is capitalism and people being able to go in and buy this ground and farm it. And in most of the basins that you're talking about, the amount of money that the state is offering for just the water, not the land, it wasn't for us it wasn't a golden parachute by any means. It was a means to an end to be able to do something else. For other people, it's a means to an end to be able to get out. Nobody's coming to Diamond Valley, Nevada to farm. They're not coming in by the droves. We're not Idaho. We're not California. So I think when you hear opposition that speaks to people saying that, you know, you're taking this land away, you're taking this land out of production, in some cases, maybe, but across the board in the state of Nevada, I don't think that that's a valid argument. Thank you.
Thank you, Madam Chair and members of the committee. For the record, I'm Deanne Moyle Hicks, Moyle-Hicks. This is my sister, Denise. I too, we farm together, the three sisters. I wear many hats in many communities, and the proudest hat that I wear is being a member of our family farm that my dad established in the late 70s. It's a pride and a joy for me to be there, to think about this, to think about water. As I was coming here, I was thinking about when we were kids and we took baths in 50-gallon barrels and we swam in horse troughs. We played in the sprinklers, we changed hand lines, we changed wheel lines, and so water was just about everything. My favorite memory is we're laughing at one another because our hair is standing up because we're changing wheel lines in a thunderstorm. Right? Not a good idea, but the work has to be done, and so we're going to get the work done. We contemplated a lot about being a part of this program, what that would do to impact our business as farmers, our family business, and what that would mean for us. We spent a lot of time talking about it. Do we want to? Do we not want to? A piece of wanting to is that my 10-year-old nephew sitting in the back of the room here today, is there an opportunity if he wants to be part of this family farm? Will there still be an opportunity for him to be part of the farm? My 22-year-old son is on the fence back and forth. Does he want to farm? Does he not want to farm? And my goal is to set him up in some sort of a way to be successful, that if Diamond Valley is where he wants to come, we're going to make sure that that's going to be available for him in the future. So as you consider this bill, as you consider moving forward, the one thing I would ask for you to do is please stay curious. Please think about what this can and can't do. We don't know the ramifications in the long run, right? But we do know that we have an opportunity to do some conservation in a different way than we've done in the past. And ultimately, in the end, this bill creates a choice for farmers, and that's where the choice should be.
Thank you. AVH, is there anyone on the line wishing to provide support testimony for Senate Bill 36?
If you would like to testify in support of SB 36, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of SB 36, please press star 9 now. Chair, you have no callers wishing to supply support at this time.
Thank you, AVH. Next, we'll take testimony in opposition for Senate Bill 36. Anyone here in person in Carson City that would like to provide testimony in opposition? Seeing none and seeing none in Las Vegas, AVH, we're gonna move to the phone lines for opposition. Is there any callers on the phone? Are there any callers on the phone that would like to?
You have one caller on the phone, Chair.
Okay, go ahead.
If you would like to testify in opposition of SB 36, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to testify in opposition at this time.
Okay, now we're gonna take testimony in neutral. Is there anyone here in Carson City that would like to provide testimony in neutral for Senate Bill 36? Seeing none here or in Las Vegas, AVH, we're gonna move to the phone lines for anyone wishing to provide testimony in neutral for Senate Bill 36.
If you would like to testify neutral on SB 36, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to participate at this time.
Okay, would you like to come back? Okay, waiving our final remarks, I will now close the hearing on Senate Bill 36 and allow my colleague to come back to the dais here. We are moving on to our final business, which is public comment. But before we start that, I would like to, you might have seen all three of us women here are wearing white coats today. We are wearing white coats in honor of International Women's Day. And I just wanted to take a moment on behalf of the committee to thank our mostly female staff here. So Sherry, Donna, Erin, and Danny, thank you so much and Jennifer, just kidding. Jennifer's my favorite staff member, now I have to say that. Thank you for everything that you do to prepare us, and run a great meeting, so thank you, ladies. We are now going to move on to public comment. Is there anyone here in Carson City that would wish to provide public comment? Okay. AVH, is there anyone on the phone line that would like to provide public comment?
If you would like to provide public comment, please press star 9 now to take your place in the queue.
This isn't actually public comment since I tried to get in both under opposition and neutral. Good afternoon. My name is Robert Coachy. I'm the former Deputy State Engineer with over 4 decades of experience in water rights related work, both in the public and private sector. Today I'm representing myself in opposition of SB 36. It's my firm belief that we cannot buy our way out of our groundwater issues, and this bill will not resolve the challenges we face. The execution of the previous 2023 legislative pilot program exemplifies the flaws and waste inherited in SB 36, even though there's not public money being looked at this right now from the state of Nevada. Based on the information I have to date, the 2023 pilot program led to the purchase of over 21,000 acre feet of groundwater rights at a cost of around $25 million. Of the water rights acquired, approximately 50% comprised of dry water, meaning these were paper water rights with no actual beneficial use. Thousands of acre feet of wet water were purchased in areas where no existing water rights were impacted directly or through groundwater surface water interaction by the acquired water rights, and thousands of acre feet were purchased in Diamond Valley, which already has a groundwater management program in place approved by the water right holders in Diamond Valley to bring Diamond Valley into balance within the perennial yield. As a result, millions of taxpayer dollars were spent on water rights that had no impact on the environment, conflict resolution, or were already part of an active groundwater management program put in place by the water right holders, all of which wasted millions of dollars of taxpayer funds contrary to the intents of the 2023 legislation. I previously testified asserting that no public funds should ever be allocated to a groundwater buyback program when the state engineer already possesses the statutory authority to address groundwater conflicts and conjunctive use issues. The wasteful expenditures of millions in tax dollars money on the 2023 buyback program underscores the ineffectiveness and wastefulness of such a program. Instead, any potential public funds should be
Thank you
invested in
so
actual
much. You have
science to identify
exceeded your
problems
time and
and
you can
support resolutions
submit
under
public
existing
comment.
statutes. Thank you.
Thank you. Okay, so
Thank you.
now, AVH, is there anyone else on the line that would like to provide public comment?
Chair, you have no more callers at this time.
Okay, seeing no further public comment, I want to give you a heads up that we will be having our next meeting on Tuesday, March 11th, and we will be canceling next Thursday's meeting. And we are going to adjourn this meeting. I hope everybody has a great day.
Thank you, Chair.